SJC-13492 in the matter of an impounded case, and SJC-13493 in the matter of an impounded case.
Okay, Attorney Chayette?
Yes. Yes. Thank you, Chief Justice Budd, and may it please the court. My name is Kara Chayette, and I represent the two juveniles. These courts have been paired because they raise identical statutory and vagueness challenges to Chapter 123, Section 35. And I do expect to devote most of my time today to those issues, but I'd be remiss if I just didn't put a pin right up front, that even if the court disagrees with me on the constitutional and the broader challenges, that there are very fact-specific reasons why my clients are entitled to have their commitments vacated, and the complete lack of findings in the young man's case in Bristol County and the court's really problematic least restrictive alternative analysis in the young woman's case in Essex.
Can I ask you about that? Because I was curious, because I think you've got a very good argument on JP. But on ES, there was an issue where there was an inquiry about other available less restrictive placements, and that none seemed to be available. Why was that deficient?
Well, because sort of think in terms of the order of operations, this we'll get to what I claim are a lot of the procedural defects that animate my constitutional challenge, but this isn't really a phased statute like Section 12 is, but there are you make one determination and then you move to the next and then you move to the next. So is there a substance use disorder? Is there the very imminent likelihood of harm absent hospitalization? If so, if there's that grave danger, is there some lesser restrictive alternative to hospitalization? What the judge did was, having heard the clinician that my client didn't meet the harm criteria, well, if there's no other alternative to hospitalization, isn't she in danger? She flipped the analysis. That's my problem with that. And the fact is,
I don't see that. I thought she did it. I thought she did it right. You've got the second ES is using fentanyl. She's disappearing for 4 or 5 days without telling her parents where she is. We have a clinician finding that she has the disorder, and the judge is going, do you have any place to place her? Do you have any place to place her? And he even has the person come out of the room and come back to the room, and they said, we still don't have anywhere to go.
Right.
Isn't that no less restrictive alternatives?
Well, so I don't want to, again, part of my big claim is that given that the clinician said this young woman does not meet the criteria for commitment under any of the harm prongs, I think if you read that transcript, there's the judge, here's the clinician, and just keeps, well, you say she's not a danger, but what about, is there any other place for her to go? Don't you have to go and investigate that? And there was a little bit of badgering of the judge to this clinician to change her testimony if there wasn't another place available that afternoon.
Because there are 3 parts to this statute, right? And the first part, just to put my cards on the table, I tend to agree with you that we need medical testimony. It's necessary. It may not be sufficient, but it's necessary to support a finding that you meet these 2 diagnostic criteria. I don't, though, find that you need, a judge can decide how dangerous that person is without, that's not a medical determination, whether they're going to harm themselves or someone else, particularly if they're taking fentanyl and disappearing from the house for 4 or 5 days. And how old is she, 16?
She's 16.
To me, that's like red flag danger. And even a judge can do that without medical testimony.
I cannot point the court to one definitive place that stands for that proposition. But part of the, but
I can.
Oh, okay.
7 and 8s.
Well,
I mean, 7 and 8s. That's what the judge does. The judge makes the determination on whether or not they're in danger either to themselves or to someone else, or whether or not and the judge can do that based on the testimony on the first part. So the judge does it in 7 and 8.
But in every other commitment provision, there's been some clinical professional evaluation that indeed the person being drawn into the court to be further evaluated, that there's been some professional assessment that indeed this person falls, we have reason to believe that this person falls within the ambit of the statute.
Can you help me, like, on an incompetent to stand trial and you have the security of Bridgewater State Hospital? My reading, my memory is that the clinician, of course, on a Section 15 testifies, and usually in court, on a 15A, I guess it is, it says that this person is not competent to stand trial. And then the next inquiry by the court is, where should we place this person? And we've been pretty strict on this and say, well, if they're harm to themselves or others, they have, in their mail, they have to go to the strict confines of Bridgewater. Is it that the judge gets to do that? The clinician doesn't say the placement. The judge gives the placement, correct? Or am I wrong about that?
You know, having never appealed or litigated one of those, I don't feel competent to answer
I'll
that
look it up.
particular question. But I'd actually, I think when we start thinking about 15 and 16, I'd actually point the court to Garcia. In Garcia, right, so there's a full-blown trial with all of its procedural protections, and then there's the question about whether this individual who's been found NGRI is going to be hospitalized. The Commonwealth bears the burden of proof. The Commonwealth's expert says this individual does not need to be hospitalized. And the court registers in its decision its concern about the fact that there was no competent expert testimony that the individual needed hospitalization, and says in a footnote, we leave for another day whether expert testimony is necessary to make this kind of a commitment decision, because otherwise it leaves unfettered discretion in the hands of a judge to determine who falls within the ambit of a statute. And at points in that footnote, the court looks to 123A. And that's one of my other arguments, that we've got so coming back to...
Let me just stop you right there for a second. That's an interesting point, but in Garcia, we're talking about commitment to a locked facility and the like after an NGI finding, right? Here, we've said before that Section 35s, although they obviously implicate a liberty interest, and you've done a great job of telling us what that is, it's less restrictive than an NGRI finding, right? NGI finding.
Well, so you mean the commitment that followed, like in Garcia, it was a 40-day evaluation, right, in the hands of some clinical professionals to determine whether, in fact, the person should be subjected to a longer hospitalization.
Because there are gradients of these things. In the legislature, like in the sexually dangerous persons with the QEs, they've said, no, you can't, and we've said, you can't do this without a QE. You need a QE. And you're basically asking us to hold the same in a Section 35.
So a couple of things on that. One, I think that when you look at Garcia, which was a 40-day hold for evaluation, that looked to the SDP context. In minor, the rule that minor imported into Section 35 commitment hearings for specific factual findings, it cited to SORB cases for that proposition. SORB and SDP are different, but they're also looking at these predictive dangerousness assessments of individuals. There are a couple of other cases. AM also cited out to 123 as an analogy, because that's what we do, right? We argue by analogy. But the Garcia case, and then if I can a little bit get to Justice George's question, because a case that I found as I was preparing for argument was Carrillo, which I hadn't read before. I had not registered that the site is 483 Mass 269. I hadn't registered originally that it had any connection at all to Section 35, but in listening to the oral argument, thank you, Fran Keneally, for getting all those on the website. Actually, Justice Gaziano, you raised Carrillo in that case. That was where you vacated the conviction for involuntary manslaughter because of the young man who gave his friend or distributed to his friend the heroin that led to his overdose. And an amici in that case, and Justice Gantz pressed the parties how does this fit within our Section 35 jurisprudence? If the possibility of overdose from heroin is enough to get a conviction for involuntary manslaughter, doesn't that mean that the possibility of overdose satisfies the harm criteria? And what the court said in that case is, what the Commonwealth argued was the vulnerability to overdose was heightened because the victim was in withdrawal. And it was heightened because the potency was so great. And the court said those things are not susceptible to judicial notice. There was no expert testimony that the Commonwealth offered for those, and those are not things that reasonable people would know. So that, I think, is the closest that I can get to, that when you get to that harm criteria, that's sort of the rubber meets the road. And the other thing that I draw the court's attention to in terms of the procedural deficits in these cases, right? There's no notice. You get dragged in. You know, my loved one can say, Kara has a problem, and I have no notice. I'm in front of a clinician getting evaluated. There's really, I know the amicus argued that these are really adversarial proceedings, but who's the adversary? The judge is the fact finder. The judge is applying the law to the facts. The judge is like the prosecutor, and certainly in the Essex case was. And if the judge can say, well, fentanyl's really toxic, right? I mean, what are the effects of that? Then the judge is effectively opining.
But I think, well, actually, ironically, one problem you have in Carrillo is that we said that heroin, as it is, isn't enough. And then we wrote, except if there's fentanyl.
Well, no, but that's, first of all, that's combining, if heroin is laced with fentanyl, but it would have been, so that would have been one of those X factors that
Right, that was a plus
might
factor.
have gotten
right.
them. But the other thing I didn't include in my brief, I was running up against my word limit time. But so we say, if you were to tell me, well, SDP's its own thing, you know, one day to life, we're not going to analogize for that. Then why is it that if I'm sued for malpractice, the plaintiff doesn't even get to the jury if there's not an expert about the standard of care, right? I mean, so my reputational harm, my investment in my education is sufficiently protective that there's got to be an expert that's going to stand between me and a jury. But in these cases, a family member, and it's almost all a family member.
Not if we impose what you say on the first prong, which is you need clinical support for a diagnosis that you meet the alcohol or the substance abuse syndrome or whatever. I'm not using the proper terminology. So say we give you that, and we think you're right on that point. And we have a kid on fentanyl running away from home. You know, we have all kinds. You know, this is what we can do, right? We can make those kinds of calls. We can't decide whether you have a substance use disorder. That's a clinical decision. But we can decide, oh my God, there's a real danger that kid's going to get hurt, and honestly, that the clinician is silly to think that that's not dangerous. Because we know too often about those kids who disappear from their home and get hurt when they're on drugs. So I mean, we know a lot about that.
But Justice Kafka, remember, these are supposed to only happen in emergency, right? So a couple things. Yes, we as reasonable people, you as jurists might look at a situation and say, well, geez, that sounds dangerous to me. But the statute is supposed to be this carefully circumscribed tool, and the danger has to be due to the disorder, not to just adolescent rashness. In the young woman's case, she'd had 2 mental health lockups for 2 years prior, and she fled when she was basically said, you're going to this place voluntarily, or we're basically going to put you in handcuffs and take you there. And she ran. And for the 5 days that she was gone, she was texting her mom, letting her mom know that she was safe. Mom didn't say that those texts sounded like she was loopy. There was no indication that she was high when she came back on her own. She asked her mom if she could come home. I understand that these are dangerous, but there's got to be a closer connect. And
Well, Well, the alternative is we're endangering kids going too far the other way. I get the first person, he's classic. He's smoking too much marijuana. In the old days, he would be growing his hair long. Now he's cutting his hair off, you know. It sounds like this is not the kind of thing we want to institutionalize somebody, but he's quite different from the second child.
All right,
you know.
well, so on the sort of the parade of horribles, and I'm going to watch I do actually want to talk about the chronic, the vagueness issue, even given what you said. But the court's core judicial function is to construe statutes consistent with the Constitution. So what would happen if we were to do it, you know, that's a little bit, again, order of operations out. First, test the statute, and if it's not carefully circumscribed, as I contend it isn't, then what do you do?
I thought we did that in matter of minor. We told them the order of operations in matter of minor, right?
I'm sorry.
We told juvenile judges what to do in matter of minor, as far as the order of operations.
Oh, no, but I'm talking in terms of this court's consideration. It's sort of, that I don't think that you don't not get to the most extraordinary relief that I'm asking because of what might happen next. And if I can channel Justice Lowy for a second, in Chapman, I consumed so many oral arguments in the last few weeks, but during Chapman, the Commonwealth wanted you to overrule Johnstone. And the Commonwealth's argument was you couldn't have anticipated the consequences of that decision. And Justice Lowy said, that's a legislative decision. We look at the Constitution, we construe statutes that way, and then the legislature can fix it. You know, in Bruno, the court noted that for 10 years there'd been no classifications for SDP, no commitment hearings for SDP, because the statute had been, I guess, it had been reversed. I don't know the history of that statute, but for 10 years that didn't happen, and we survived. And SDP is much graver concern and danger to the public. We're looking at the most sort of the most extreme state power when we're talking about protecting people from, you know, their worst moments.
Counsel, I don't disagree with you in the stuff that you let, the lead up to it is very difficult, and I hear you. You know, somebody comes in for a warrant of apprehension, they have no idea, they haven't done anything wrong other than potentially being sick. But I give you, and I'm with Justice Caffer on this one, because as a practical matter, we do tether the first finding to what the clinician says. It might not say that explicitly in the statute, but I don't think you hear any judge say, I credit what the clinician said and find the first prong. The dangerousest prong is the stuff that I'm really having an issue with. Judges do this all the time, and they do this, and we mentioned some other context, but we do it in bail, we do it in 58A. Judges all the time have to make determinations about the prospects of harm. So why do we need a clinician to say, in my clinical judgment, I think that X? Why does the judge need that?
In part so that partly because I think that some of what happens and what happened in my cases, in particular the Essex one, is you've got a parent who's very sympathetic, who's legitimately concerned about her daughter, and you've got a clinician who, you know, is sort of a neutral arbiter, says, there's, you know, where's the imminence of harm? We may have a possibility of harm, but she's taken 3 doses of,
But hold on, but they're not a neutral arbiter, though. I mean, you mentioned what the judge is. The judge is both the finder of fact, so that's a witness. And the judge is free to not credit that witness when the witness says, I think this person can be out in the community.
But again, I think it's about sort of, do you get over like a required finding? If there's not competent evidence, and given this, I mean, there's a little bit of, why not require that there be some professional assessment? Yes, the judge can decline if clinician says...
What's the role of the judge then in this?
To evaluate all of the evidence.
Okay, so, right.
Absolutely to evaluate, but you're missing competent
So
evidence.
it's basically heads I win, tails you lose. So if the clinician says this person should not be committed under your view of the constitutional provision or limitations, the person can't be committed, just like QE.
Yes.
But if the clinician says this person can be committed, the judge, and only then, can say, I don't credit you and I'm not going to commit.
And the findings of the judge should explain why she doesn't credit the expert's testimony.
But isn't that, you're sort of running right in the face of the legislature going the opposite way. Now, I understand, I want you to address Keniston before you sit down too, but the legislature is saying, the way it redrafted the statute, it's moving away from, it's going the exact opposite way that you're arguing. Now, we may need to make a correction, at least on the first part, but it's certainly not what they intended, that's for sure.
May not be what they intended, but I'd point the court cited to the 2019 Section 35 Commission report in, I think it was in GP, no, it might have been minor. And on page 8 of that report, there was a recommendation that the Commonwealth should commence a process with the goal to reduce or eliminate the use of 35, as there is insufficient evidence of its efficacy to justify the deprivation of individuals' civil liberties. 6 people on that commission said, yeah,
Okay,
that's what we should do, and 3 people
Before you
said
sit
no.
down, Keniston, isn't it, can't we just say, okay, the legislature softened the first prong. Whether they may have done that, but they can't constitutionally, so we fix that problem. Your brief suggests we can't fix that problem. We have to declare the whole statute unconstitutional. I don't, why?
Well, I mean, there's the court's jurisprudence on Section 123 has certainly embraced a lot of kind of importing standards and requiring, sometimes declining to import language and standards. But as you just said, how do you reintroduce a standard that the legislature stripped out?
Because they softened it thinking that they could constitutionally, but they can't. And we're going to say, no, you gotta, it needs to be supported. We've been doing, I mean, our whole case law in this area has been toughening up these statutes, haven't they?
Are you going to hear me complain if you judicially amend the statute? No, but I don't. I actually.
Justice Lowy will be very unhappy with you.
But and I know that my time is up. There was one brief point I wanted to make on the chronic and vague, just because the Donahue issue that you can't, if the subsidiary clause of the harm in the substance use disorder, if that's modifying chronic use or habitual use, then you just get rid of chronic and habitual and it means the same thing, and words have to have meaning. But there was a point that I didn't make in the brief about Donahue that I really want to make. That case in which the appeals court said that chronic and habitual was unconstitutionally vague,
We fixed that, right?
yeah, but the point.
This is Justice Milkey's concurrence. We fixed that, right?
Oh, right.
We said that chronic has a different meaning. Didn't we correct this?
For purposes of Section 35?
I thought we've addressed the problem that Justice Milkey has identified. I wrote a decision.
Oh, this just on Donahue, that in that case, the question was, physician Smith, physician A, has a patient who's taken 3 tabs of fentanyl in a month and says, I don't think that's chronic use, so I'm not going to report to the DPH. Physician B says, yeah, 3 tabs of fentanyl in a month, I think that's chronic. I'm going to make that report. Physician A was criminally prosecuted and physician B wasn't, and the court said, and of course now I don't have it in front of me, but vagueness is about sort of arbitrary assessment of things, and now you take those physicians and drop them into a Section 35, and physician A says, yes, this young woman has a chronic disorder, and physician B says she doesn't. There is no standard for chronic or habitual. It's not defined anywhere further in the statute, and and I don't know that the court
It's
can
not
define
defined in
it.
the medical, so the physicians who are testifying on chronic, there's not a standard in the medical literature on that?
Well, you know, as far as the AG is concerned, to demand that this be a diagnosis is sort of, you know, reading a whole panoply of protections and time into this. And the fact is that the statute used to require, I think it was a psychologist or a psychiatrist to do the evaluations. Now it's a social worker. Are they even able to make a medical diagnosis using the DSM? I'm not entirely sure, but I think you start to run into those kinds of problems. My time is way over. Thank you so much, and I'll stand on my brief.